Hi everyone, my name is Cora Granger and I'm a law clerk here at Perryfield Lawyers. Today I'm joined by Catherine Hattaway, who is a solicitor in our property team. Today we're going to talk you through some of the key changes to the Residential Tenancies Act, which came to effect in February of this year. One of the key changes that was made was fixed term tenancies rolling over into periodic tenancies. Catherine, could you tell us a little bit more about that change?
Sure. So fixed term tenancies are tenancies that are specified for an amount of time. And now they are going to automatically convert into periodic tenancies unless the parties agree otherwise. So to keep the tenancy as fixed term, the landlord and the tenant can agree to renew, extend, or end the fixed term tenancy before it expires. The tenant can give 28 days notice, or the landlord can give notice in accordance with the termination grounds for periodic tenancies. So it's really important that you're communicating between the parties.
Great, thanks, Catherine. And one of the other key changes was the end of the no cause termination, which has been quite scary for some landlords. Could you tell us a little bit more about this?
Well, the good news for landlords is that new causes have been added to the legislation that cover the general reasons why you might want to end a tenancy. So this includes selling, renovating, or using the property for business purposes. The notice period for terminating a tenancy on these grounds has increased to 90 days, and you only need to give 63 days notice if the property was once accommodation for employees and is needed for this again, which must be stated in the tenancy agreement, or you or your family are going to live in the property, and that's within 90 days and for at least 90 days.
And what happens if you're in a periodic tenancy and the tenant is behaving badly? What can the landlord do then?
Sure. So if a tenant in a periodic tenancy has exhibited antisocial behaviour at least 3 times within a 90-day period, and the landlord has issued valid notices in relation to this, the landlord can apply to the Tenancy Tribunal within 28 days after the third notice, and the tenancy may be terminated. So antisocial behaviour isn't strictly defined, but tenancy services have provided examples. So aggressive or intimidating behaviour, excessive noise, repeatedly parking over a shared driveway, or leaving rubbish in shared areas. So the same process can be followed for giving valid notices to the Tenancy Tribunal in relation to tenants who are at least 5 days late on rent, and that must be on 3 separate occasions within a 90-day period.
Thanks, Catherine. What about if you're a tenant and you're wanting to end the tenancy?
It's really easy for tenants. They must give 28 days notice to end the tenancy. That was formerly 21 days, so it's a little bit of an increase there, and you don't need to give any reasons.
Great, thank you. And for tenants who are wanting to make minor changes to the property, what are their rights in relation to that and what's the process?
So tenants can ask landlords for permission to make minor changes to the property, and the landlord can't decline if the change is minor. So minor changes are easily reversible, and they include changing the curtains, baby proofing, or maybe earthquake proofing by securing the furniture to the wall or something. And tenants need to apply in writing to the landlord, and the landlord must respond to these requests within 21 days.
Okay, great. And if you're a tenant wanting to assign your tenancy to somebody else, what's the process for that?
Landlords need to consider all requests to assign tenancies and can't decline unreasonably. Landlords can also recover reasonable expenses from the assignment process, provided that tenants are given an invoice that shows the breakdown of costs.
Okay, great. And what about rental bidding? Could you tell me a little bit more about that?
Well, this is another attempt from the government to ensure that tenants have a place to live. I know that rental bidding was a bit of an issue in some student areas. So rentals do need to be advertised with a price to ensure that tenants don't bid to secure it. But it is interesting that a prospective tenant can volunteer to pay a higher rent price, and this can actually be accepted by the landlord.
Thanks, Catherine. And what about fibre broadband? Can a tenant require fibre broadband to be connected at a property?
Yeah, it's interesting. The law is moving with the times, and the Act now provides for the installation of fibre broadband. Tenants can request the broadband, and landlords must agree if it can be installed at no cost to them. So there are examples where you could be exempt. So if installation would compromise the property, it might compromise the structural integrity, the weather tightness, or the character, breach regulations, or if the Tenancy Tribunal decides against it. Also, if the landlord is starting renovations on the property and that would be affected by the installation, then those would be some reasons why fibre could be denied.
Great, thank you. And some of the other changes that were made under the Residential Tenancies Act were in relation to changes to the Tenancy Tribunal. What were those changes?
So the Tenancy Tribunal can now hear claims of up to $100,000, which is double what it used to be able to hear. And if you have a successful claim at the tribunal, you can now apply for your personal details to be removed from the tribunal's records.
Okay, and landlords, are they required to hold any information or records?
Yes, they are. So there have been changes to the landlord's obligations to keep and provide tenancy records. And this includes information about healthy home standards, maintenance records, inspection records, tenancy agreements, and notices to the tenants and advertisements for the tenancy. So there's really quite a lot that the landlord needs to be keeping.
Perfect. And are we expecting any other changes in the next while?
We are. So this is the third lot of changes for the Residential Tenancies Act within the last wee while. So we've just talked about phase 2, which was the February 2021 changes, and phase 3 is set to arrive when new regulations take effect. So that will allow tenants experiencing family violence to leave a tenancy with no financial penalty, and allow landlords to issue a 14-day notice to any tenant who the police have charged with assaulting the landlord, the owner, a member of their family, or the agent.
Great. Thank you very much for talking us through some of those key changes, Catherine. Here at Perryfield Lawyers, we have got a number of different lawyers available who would be able to assist you and answer your questions in relation to residential tenancies. For more information, you can visit our website at www.perryfield.com. If you go to the Our People tab, that lists all the lawyers who work at Perryfield. And we also have a resources tab, which has a number of different articles and videos that may be of assistance to you.